In this lesson, what we're going to do is take an introduction to the grounds for judicial review. Now, this is going to be one of the most substantive topics we do when we look at public law, given the fact that the grounds for judicial review is one of the most important parts of our studies in judicial review. And then after this, we will cover the issue of police powers and all the other elements that exist within administrative law therein. Now, we're going to be moving on to topic 4 in our series on constitutional and administrative law. Topic 3 essentially covered the focus on the idea of judicial review, what judicial review is, how it works, who can bring a claim, and who is considered to be a public institution for the purposes of judicial review. Whereas topic 4 is talking about the various different ways in which judicial review can be grounded. On what basis can it be claimed that judicial review is taking place, or that needs to take place in a particular circumstance? Namely, under what grounds, under what justifications does a court have to declare that a particular piece of legislation or a particular act by a public authority, by government, is going to be falling outside the remit of their requirements, and so as a result of which cannot be considered to be lawful? We'll outline the grounds for judicial review in this lesson, outline the case which illustrates the grounds for judicial review, before examining them in more detail over the next few lessons' time. There are quite a few, and there's quite a few different elements that we have to think about and discuss, so we're going to spend quite a lot of time talking about this fourth topic, the topic on the issue of judicial review and its grounds. So, the case that discusses and outlines the formal grounds for judicial review is the case of the Council of the Civil Service Unions versus the Minister for the Civil Service. This is a case from 1985, and the facts of this case are as follows. The Minister of Civil Service at the time was Margaret Thatcher, and they had made a decision that those who worked for the British Intelligence Agency at GCHQ ought not to be allowed to join a trade union. Now, Thatcher made this argument on the grounds of national security interests. So this is something of an infringement on, of course, the rights of employers at work and employees at work. However, it is justified on the basis that individuals who work for GCHQ ought not to be able to join a union and because of the national security interest that may be infiltrated as a result of this. Don't forget that, of course, in the 1980s, there's quite a lot of in domestic terrorism, essentially, taking place with the troubles in Northern Ireland. This obviously doesn't get resolved until the Good Friday Agreement, long after Margaret Thatcher has left office. So this decision was implemented, and Thatcher sought to implement this decision using the royal prerogative, and she did so by issuance of an order in council. If you want to know more about the way in which the royal prerogative works and orders in council work, we have a lesson on this when we looked at the English legal system a good few months ago. The CCSU then challenged this view on the ground of judicial review claims, challenged this, and the House of Lords was invited to answer a number of questions in relation to this case. Firstly, they had to ask the question of justiciability. We've already covered what it means for something to be justiciable, and justiciability when we looked at the second Miller case. Essentially, is this an issue that is in the remit of the courts to discuss and to be able to adjudicate on? Is it justiciable? Because in some circumstances, the use of the royal prerogative is not justiciable, and in other circumstances, the decision that is made is a political decision, which may or may not, therefore, be justiciable in the courts. If the answer to the first question is yes, that it is justiciable, then the second question is whether or not the decision is in fact legitimate. And so, on the justiciability ground, the House of Lords concluded that the decision was indeed justiciable. It was held that the justiciability of a decision made by the royal prerogative can be legitimised on two grounds. The first ground was that the decision in question altered the rights or obligations in the private law. The second ground for which justiciability can actually be justified on the basis of decisions made by the royal prerogative is that they may deprive a benefit which they either did have or were reasonably expected to have, and so as a result of which the fact that they did not, or the potentiality that they may not, and that this had been deprived, suggests that there is a certain justiciability in that decision. So, in concluding that it was justiciability, the next question for the House of Lords was whether or not it in fact was legitimate. And here the courts actually give us the grounds for judicial review. According to Lord Diplock, the grounds for judicial review of an action may be made that are made by the executive are the purpose of illegality, the idea of irrationality, the idea of procedural impropriety. And these are the three major grounds of judicial review, and then there are sort of sub-elements that needs to be discussed in relation to this, things like legitimate expectations, natural justice, as well as proportionality. But fundamentally, the three major grounds for judicial review is that the decision is potentially illegal, it is potentially irrational, and then there's this final issue, this idea of procedural impropriety, all of which we will get to throughout the next few lessons' time. In the previous lesson, what we did was take an introduction to the various different grounds of judicial review. And we illustrated the case that essentially gives us each of these different grounds for judicial review, the grounds in which a decision can be challenged by the executive on the basis of whether or not that decision has or has not acted in a particular or has been essentially achieved in a particular way. The first of these is illegality, the second is this idea of irrationality, and then the third is the idea of procedural impropriety. This lesson specifically is going to talk and take an introduction to the concept of illegality, the first major ground of judicial review. We'll examine the nature of judicial review being justified on the grounds of illegality. Specifically, we're going to be looking at something known as the ultra vires doctrine, something that you should know about a little bit already, potentially, given that it's so commonly described and spoken about in the literature, and examine its meaning and examine its scope and the way in which it has widened in scope over the last few decades. So let's begin then. The ultra vires doctrine. Ultra vires simply means beyond one's authority. And what this essentially does is it ensures that public bodies do not act beyond their authorities and power in making decisions. If a public body or an executive decision is considered ultra vires, then it is considered to be acting a decision that has been performed outside of the power that that particular public body or executive actually has. And where they do, it can lead to a successful judicial review case on the basis of the illegality principles. Given the fact that if you are acting beyond the authority and the powers that have been provided to you within statutory authority, then you are considered to have acted illegally. You are considered to have acted outside the remit of your particular jurisdiction, of your mandate. And so, as a result, you have acted beyond your authority. The case from 1921 of Attorney General versus Fulham Corporation was a case which concerned a policy on the part of the Fulham Corporation to provide a laundry service to ratepayers in Fulham. Now, I've just jumped into this and I'll explain why this actually illustrates the point that I'm trying to make here. According to the defendants, the, quote, Baths and Wash Houses Act of 1846 to 1847 gave them the power to do so. A very, very important piece of legislation, I'm sure, that I'm sure every single law student has read from cover to cover, the Baths and Wash Houses Act. This was, therefore, a case which concerns whether or not the Fulham Corporation had acted beyond their authority. Whether or not they had exceeded their statutory obligations and powers by essentially going beyond what was granted to them in the Baths and Wash Houses Act. The court had held that they had acted ultra vires. And so, as a result of which, they exceeded their statutory authority, and so the decision was considered to be illegal, and as a result of which, the judicial review claim was successful. When we talk about the ultra vires doctrine more specifically, It can also refer to circumstances where it has been alleged that there has been an abuse or potentially a misrepresentation or misinterpretation of the statutory authority. This has been seen in recent decades as something of an expansion of the ultra vires doctrine. So rather than it being just the case that you have a specific remit within the statute and you have acted outside that remit, instead you may have abused your authority, or you may have misinterpreted your authority. The result is theoretically that you have still acted outside of it, but you have acted outside of it in a way that is different to an ordinary and traditional understanding of what the ultra vires doctrine tells us. Where there has been a circumstance in which a public body has made a mistake at law, which takes them outside of the powers that have been enshrined to them to statute, so where they have essentially mistaken what the statutory authority is telling them that they can do, and this mistake at law takes them outside of the powers, and so therefore they act ultra vires as a mistake of law, they have made, as the courts define it, a jurisdictional error. They have made a jurisdictional error when they do so. The court's findings of jurisdictional errors can actually be very, very broad in scope, and so also represents something of an expansion of this idea of ultra vires in the recent decades in which the legislation has, or at least in which the principles have been spoken about and been discussed. It does not just refer, for example, to the circumstances where there is a mistake at law, which is, of course, the beginnings of the conversation when we think about jurisdictional errors. But now it also could be suggested that it includes a misrepresentation or an abuse of power. One such example of this is the failure to take into account relevant considerations in the decision-making process. This is considered to be a jurisdictional error and could cause the decision-making authority to fall outside the scope of their statutory obligations, and as a result of which have acted ultra vires. Another alternative is this idea of potentially taking improperly taking into account of irrelevant considerations. So the idea of so this is obviously the other side of the coin in relation to the jurisdictional error. You have on the one hand the failure to take into account relevant considerations, and then you have on the other hand the improper taking into account of irrelevant considerations on the other side of the coin. The next lesson will talk about these relevant considerations in more detail, but I'm just going to leave it here thinking about the ways in which the ultra vires doctrine has expanded significantly, potentially, in scope, such that it does not just include acting beyond one's authority, but it also includes failing to take into account relevant considerations, a mistake at law, a misrepresentation or an abuse of power, which leads to the result of acting outside of one's authority. In this lesson, we're going to cover the issue of improper purposes as being part of the illegality grounds for judicial review. We'll examine over the next few lessons the different varieties and actions and decisions that are taken which may be grounds for judicial review claims on the basis of illegality specifically. This lesson is going to spend some time examining the nature of where a decision could be taken for an improper purpose. Now, when we think about the idea of improper purposes, we basically come to the conclusion that if a decision is taken by some kind of public authority, public body, and it is done so for an improper purpose, then this can be a ground for judicial review on the basis of illegality. So you're questioning the reasoning behind the decision that is being taken. Is that reason a proper reason? Is that a proper purpose, or is it not? This is a question that you must ask. The case of Padfield noted that the discretion of a minister in the exercise of statutory authority has to act within the rules of the purpose of the act. Not to do so would be acting with an improper purpose. So let's think about this case then. Let's think about the case of Padfield versus the Minister of Agriculture and Fisheries. This is a case from 1968 where the claimants had been milk producers, and they had argued that the prices of milk ought to be increased owing to an increase in the transportation costs for that milk. Now, the price of milk was fixed by the, quote, Milk Marketing Board, which was operated under the remit of the Minister of Agriculture and Fisheries. So these milk producers argued essentially that there's been an increase in the transportation costs of this milk, so as a result of which there should surely be an increase in the price of the milk so that we make more money, so we don't have to fork out revenue on the basis of the transportation costs. That's essentially the point. And the Milk Marketing Board are the people who essentially fix the price of milk, and this is done under the remit of the Minister of Agriculture and Fisheries. Now, under Section 19 of the Agricultural Marketing Act from 1958, another piece of legislation that I'm sure every single law student will be rushing to read from cover to cover, there was an obligation for the minister to appoint an investigation committee on the basis that transportation costs ought to be accounted for when we think about the price. So theoretically, if the transportation costs of milk increases, then according to Section 19 of the Agricultural Marketing Act, then there must be a way of investigating this such that the transportation costs therefore would be accounted for when looking at the price of the product. The minister refused to appoint such a committee, and they justified this decision on the grounds that it would cause economic difficulty if the price of milk were to increase. So they were making essentially a political decision, let's be honest, because if the price of milk increases, that obviously adds to the economic difficulty, and then there's the perception of a poor economy, and then when an election comes along and the manifestos are released, the opposition party will say, look, these people increase the price of milk. And when you think about it, it's those kinds of decisions, the day-to-day decisions of things like the price of milk, that ordinary voters are going to really resonate with more than more theoretical decisions or things like foreign policy, for example, because, of course, that affects everybody. If the price of milk increases, then for the most part, everybody is going to be affected by that decision. So there was a refusal on the part of the minister to do this, which was under their statutory obligations under Section 19 of the Agricultural Marketing Act from 1958. The House of Lords then held that a judicial review action can actually be brought on the basis that not appointing an investigative committee in this regard would frustrate the proper purpose of the Agricultural Marketing Act. So if you fail to fulfill your obligation as a Minister of Agriculture and Fisheries under the Agricultural Marketing Act, then you are frustrating the proper purpose of that piece of legislation. Quote, Parliament must have conferred the discretion with the intention that it should be used to promote the policy and objects of the Act. So there is discretion on the part of the Minister of Agriculture and Fisheries for them to appoint the investigative committee. But really, that discretion isn't unlimited. It's not unlimited discretion, because it should still fall within the remit of the legislation itself, the intent of the legislation, the objects of the legislation. And so if it fails to meet that obligation, then you are suggesting that there is an improper purpose that has been established here. The minister's decision to refuse to appoint such a committee, just on the grounds that it would increase economic difficulty, is an improper purpose for the use of Section 19 of the Agricultural Marketing Act. And so this passage essentially highlights the purpose and the nature of improper purpose, the idea that Parliament must have conferred the discretion when it comes to this piece of legislation for a reason. There must have been an intention behind it. And so if you have that discretion and you make a decision on the basis of that discretion, but you do so in a way that seems to contradict or go against the intention of the Parliament for creating the legislation, then it is implied that you are acting out of an improper purpose. Another such illustrative case is the example of the Crown versus Foreign Secretary. This is the World Development Movement case from 1995. And it's a case which illustrates that the idea of proper purpose of a statute, and therefore the extent to which a public body has acted within the remit of said proper purpose, is a matter for the courts to decide. The determination of proper purpose is a court determination. It was a case which involved the decision by the Foreign Secretary to approve aid in Malaysia for the construction of a hydroelectric power station. Now, authority to approve such aid would be granted in Section 1, Subsection 1 of the Overseas Development and Cooperation Act from 1980. This was a piece of legislation which essentially gives the Secretary of State, the Foreign Secretary, the authority to grant aid, quote, for the purpose of promoting the development or maintaining the economy. So, fundamentally, there is a reason for why a minister ought to be able to give aid to a particular, or to make decisions on the basis of aid and to approve aid for various different reasons. It is for the purpose of promoting development or maintaining the economy. The World Development Movement Limited sought to challenge the decision to grant aid to Malaysia for the construction of a hydroelectric power station on the decision that, on the basis, through judicial review, that the cost of the power station was far more than expected. And so, one of the things that the Foreign Secretary essentially found themselves stuck in this position was that the power station, they approved the aid, the power station was going to cost far more than expected, far more than probably the aid actually accounted for. But the Foreign Secretary did not want to pull out of the deal because they didn't want to risk a poor reputation abroad. World Development Movement argued that this is an improper reason for your discretion and your authority to approve or disapprove of aid under Section 1, Subsection 1 of the Overseas Development and Cooperation Act. The courts said the following. They held fundamentally that this decision did fall outside the scope of the proper purpose of Section 1 of the Act. And they say, quote, whatever the Secretary of State's intention or purpose may have been, it is, as it seems to me, a matter for the courts and not the Secretary of State to determine whether, on the evidence before the court, the particular conduct was or was not within the statutory purpose. So, you could understand the Secretary of State for Foreign Affairs, the Foreign Secretary's decision and the Foreign Secretary's problem in the idea of pulling out of a deal for risking the reputation of the United Kingdom abroad. But at the same time, it is not actually the Secretary of State's intention or purpose that is what's at stake here. What is at stake is the intention and purpose of the statute, of the statutory purpose of Section 1 of the legislation. And in order to make a determination on what that proper purpose is, it is for the courts to decide that. It is a matter for the courts to determine whether, on evidence before the court, the particular conduct was or was not within the statutory purpose. In previous lessons, we noted that one of the sort of elements relating to illegality as a ground for judicial review was this idea of relevant considerations, i.e. a failure on the part of the executive or the public authority to take into account the relevant considerations, or, as a counterexample, they're taking into account of irrelevant considerations when making a decision. This lesson is going to discuss this in a little bit more detail. We're continuing our conversation about illegality. We're talking about illegality as a ground for judicial review. This lesson, as I said, is talking about the nature of relevant considerations in this particular topic. Now, relevant considerations, according to LexisNexis, are, quote, those which the statute conferring the decision-making power either expressly or impliedly requires the decision-maker to take into account. So, relevant considerations, the word relevant considerations, the word relevant in this particular part, doesn't seem to attach the same kind of weight that LexisNexis actually does when they think about what relevant considerations actually are. Because according to LexisNexis, they're not just considerations which are relevant to the making of a decision. They are the things in a statute which are either expressly or impliedly required to be considered when making a decision. It means that when in the course of making decisions, a public body or statutory authority or executive authority, the statutory authority may oblige the public body to take into account a number of considerations when making a decision. If they fail to do so, then there can be a successful ultra vires illegality grounded judicial review claim. If such a consideration is taken into account, or the counterpoint to this, if considerations are taken into account when making a decision, but those considerations are irrelevant, okay, they're not part of, or either expressly or impliedly part of the statute, then the action may be challengeable by way of illegality. A useful illustration of this can be seen in the 1983 case of Bromley LBC versus the Greater London Council. Now, this was a case in which the Greater London Council had acted to implement a manifesto pledge, which would involve the reduction of the cost of tube and bus rides. So, of course, every single council, every single general election, council elections, even the elections that have just gone, that came and went a couple of days ago at the time of recording, they all obviously have manifesto pledges, and when you get elected, you have a mandate to implement those manifesto pledges. One such manifesto pledge for the Greater London Council in 1983 was the reduction of the cost of the tube and bus rides. This would be done with the issuance of a levy rate of 6.1 pence in the pound to supplement the reduction of this cost. And this is a very useful example and a very useful illustration of whenever there is a manifesto pledge that requires or that pledges or seeks to essentially reduce the cost of something, you always have to ask the question, okay, well, how are you going to do that? Now, bear that in mind, because of course there is likely going to be a general election this year, or maybe early next year. Bear in mind, the time of recording this lesson is the 5th of May 2024. If you read a manifesto and they say, we're going to reduce the cost of X, Y, and Z, you always think, well, okay, how are they going to pay for this reduction in cost? Because reducing cost is fine, there's less money going to whoever it is that cost is actually incurred onto, or given to. So, one such example here is the fact that they had pledged in the manifesto to reduce the cost of tube and bus rides, and they said they were going to do so by issuing a levy rate of 6.1p in the pound, and this would supplement the cost. This reduction would be by way of a grant to the London Transport Executive. Now, this was something that they had the authority to do, or allegedly had the authority to do, under the Transport London Act of 1969, specifically Section 3 of the Transport Act, the Transport London Act. Again, the Transport London Act is probably another piece of legislation that all of you law students are going to be rushing to read from cover to cover, given just how interesting it sounds. Fundamentally, one of the things that the Greater London Council, however, did not take into account is the fact that it is not just Section 3 of the Transport Act that they needed to consider. Because Section 7, subsection 3 of the Act obliges that the Greater London Council take into consideration the duties of the London Transport Executive when it comes to the exercising of its powers under Section 3. Now, it was held that the powers granted in Section 3 had been utilised unlawfully, and the reason why it had been utilised unlawfully was because it failed to take into consideration the duties that the Greater London Council had towards its ratepayers. So this is an example of a failure to take into account a relevant consideration, a consideration that is obligatory in the issuance of such essentially such reduction in costs, and essentially the duty towards their ratepayers that the Greater London Council failed to take into consideration of. We have two quotes here that illustrates this point nicely. So the GLC of course just standing for Greater London Council, insofar as it considered that it has a commitment to bring about the reduction in fares, regardless of other considerations, misdirected itself in law. So again, regardless of other considerations, they failed to take into account the relevant considerations that would be required in making such a decision. Therefore, the decision was considered to be unlawful. The Greater London Council could not have considered the London Transport Executive was complying with its obligations under Section 7, subsection 3. So they only really looked to Section 3 of the Transport London Act, but rather they should have also taken into consideration the relevance of Section 7, subsection 3 as well. And this is a useful illustration of how relevant considerations or irrelevant considerations can give rise to an illegality claim under judicial review. In this lesson, we're going to spend some time talking about one of the most common features relating to the grounds for judicial review. And it's in fact a feature of English law that you will be familiar with if you looked at other areas and studied other areas, because it sort of extends into different zones and different parts of the law. And this is, of course, the idea of Wednesbury unreasonableness. Now, we're moving on away from illegality as a ground for judicial review. The previous lessons talked about the idea of illegality, the concept of the ultra vires doctrine, the idea of jurisdictional errors, the concept of relevant or irrelevant considerations, etc., etc., etc. This lesson is going to start talking about irrationality as a grounds for judicial review cases. Now, irrationality is slightly different, and one of the things that we have to think about in relation to irrationality is a conversation about the idea of Wednesbury unreasonableness as being a standard that is essentially tested by the courts in relation to this area. So, even though we are going to be talking over the next 3, 4, 5-ish lessons about the concept of irrationality, this lesson is going to be focused almost entirely on the concept of Wednesbury unreasonableness. Okay? Essentially, according to this principle, we can assess the validity of a public body decision. So remember, that's what judicial review is essentially instructing us to be able to do. We can assess the validity of public body decisions through bringing a judicial review case. In fact, you do so because you have no other alternative when it comes to judicial review cases. If you bring a public authority in through normal civil litigation, in fact, the courts don't take that particularly well. They argue that if it is under the remit of judicial review, it should be brought under that remit. Anyway, so we can assess the validity of a public body decision according to this principle by ascertaining whether or not the decision was reasonable. So it's sort of a way of translating the idea of irrationality to the idea of reasonableness, and sort of instead of trying to determine and making delineation between reasonability and irrationality in terms of the law, we basically just say that irrationality can be understood in a way that is encompassing of this idea of reasonableness. Now, a decision is considered to be unreasonable, specifically Wednesbury unreasonable, and therefore, as a result of that, considered irrational, if no reasonable person acting reasonably could have made it. So the principle of Wednesbury unreasonableness is essentially one in which a reasonable person acting reasonably could not have made that decision. Not that they might not have made that decision, but something is considered to be Wednesbury unreasonable if a reasonable person, it would be impossible for a reasonable person to have made that decision, have come to that conclusion. It all dates back to a case from 1948, the Associated Provincial Picture Houses Limited case versus the Wednesbury Corporation. The facts of this case concerned the empowerment to grant licenses by the Wednesbury Corporation for the issuance of what was known at the time as Sunday entertainment. Remember, this is just after the Second World War, so things weren't that entertaining, really. So they had this idea of Sunday entertainment. One such license was granted to a movie theatre. The claimants were the Movie Theatre Corporation, the Associated Provincial Picture Houses Limited. One of the conditions of the license was that no children under the age of 15 were permitted on Sundays for the entertainment. Now, this decision was challenged on the basis that it was irrational, and as a result of which it was unreasonable. The question for the courts was whether the decision was reasonable or not reasonable. They held that it was reasonable, and it was therefore not irrational, and therefore the case was dismissed. There was no ground for judicial review in this case. However, really the outcome of this case isn't particularly relevant to us. What's more relevant is this idea of Wednesbury unreasonableness. The court considered that determining whether a decision was reasonable can be made on two different grounds. The first of these grounds was a test known as a test relating to improper purpose. The test of improper purpose essentially considered that a decision would be unreasonable if it is made either for bad faith reasons or considers irrelevant matters in the case. Both of those reasons, both of those ideas, would therefore show that there was an improper purpose. So the idea of improper purpose is encapsulated into two potential strands, the first being, of course, bad faith, and then the second being, of course, consideration of irrelevant matters. The second ground for which a decision can be understood as unreasonable is the idea of Wednesbury unreasonableness, i.e. that if an action is so unreasonable that a person who is reasonable could never make that decision, then it is considered to be Wednesbury unreasonable. On the facts, it was determined that this test was the first test was inappropriate for the conclusion of reasonableness, and so they applied the case of Wednesbury unreasonableness. And they said that it was determined that a decision to ban under 15s in theatres for Sunday entertainment fell far, 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 far below the standard that is required for this particular test. Now, one of the things that should be noted here is that it is quite a high standard, okay? It sounds quite counterintuitive. In fact, it sounds relatively tautological to say that, okay, according to Wednesbury unreasonableness, something is unreasonable if a reasonable person wouldn't reasonably have made it. That sounds just like nonsense. But fundamentally, the point is that not that they wouldn't reasonably have made it, it's that they could never have made it if they were reasonable. A reasonable person could not have ever made that decision. That's what Wednesbury unreasonableness tells us. In application of this principle, we can look at the case of R&O versus Hammersmith and Fulham LBC. What this case does is illustrate the standard which is required to show an instance of Wednesbury unreasonableness and therefore an instance of irrationality. So note here that I just mentioned previously that there is quite a high standard. This case illustrates just how high that standard actually is. It was a case which involved the disagreement pertaining to two choices, okay? The choices were relating to an individual, a child O, with severe learning difficulties, and where that child ought to live and where they ought to go to school. Since O was a child with severe learning difficulties, they fell under the remit of the Children Act from 1989, specifically Section 20 of the Children Act, which gave the local authority a duty for accommodation to be provided for him. Now, there was a disagreement between the local council on the one hand and the parents of the child on the other, specifically in relation to where O, like I said, should go and live and where they should go to school. Note, by the way, that one of the things that is often misunderstood when talking about cases involving children is that when it comes to cases involving children, the influence and interests of the parents are not as important as the best interests of the child principle. This is a fundamentally a codified principle of English child law, even of international child law, if you look at the UN Convention on the Rights of the Child, for example. When the parents sought a judicial review case in relation to the local authority's decision to allow O to live somewhere else that they didn't want them to live, the question of Wednesbury unreasonableness came up. The court concluded that there was nothing irrational about the decision of the local authority to decide in the way that it did. They did not see any irrationality or unreasonableness in making the decision that they made. And they said here, quote, "Where a local authority simply chooses one way of meeting a child's needs rather than another, it cannot be said to have interfered with the exercise by the child or the parents of their right." Simple, really. It wasn't a disagreement about if you send my child here that they will essentially not they will not be able to live and develop and go to school in the way that is required as a standard for the legislation. Fundamentally, the duty of care to this child under Section 20 of the Child Act, or the Children Act, sorry, fundamentally requires that, of course, you have a duty of care to make sure that they live and go to a good school and are in a good place. That wasn't the disagreement. The disagreement was just where that child should live. Both of these alternatives could have theoretically been satisfactory for the child, and so as a result of which, it cannot be said that simply choosing one over the other on the basis of the child's needs falls outside of the remit of the local authority in the legislation, and as a result of that, therefore falls below the standard of rationality. And so as a result, that judicial review case was dismissed. Welcome back, everybody, to our studies in public law. In this video, we're going to carry on talking about the grounds for judicial review, as well as specifically making reference to the concept of irrationality and the relationship between this and human rights law and human rights legislation and basic human rights principles in the Human Rights Act specifically. So we're continuing examining the nature of irrationality and Wednesbury unreasonableness as one of the major grounds for judicial reviews, and this lesson specifically will explore the extent to which we can say irrationality is able to afford the adequate amount of protection to those who are claiming judicial review in cases that relate to human rights. So we're essentially going to recap the concept of irrationality, which is, of course, something of a topic from the last video, but then we're going to make application to this basic principle and talk about it in relation to the concept of human rights principles. So according to Lord Diplock, irrationality is simply a different way of writing unreasonable, the concept of unreasonableness. Now, unreasonableness may be determined either if a decision is improper or if it is Wednesbury unreasonable. And we have known this from the case from 1948 of the Associated Provincial Picture Houses Limited versus the Wednesbury Corporation. This is the case which involved the idea of Sunday entertainment at a cinema, where we see the banning of people under a certain age and the question of whether or not that would represent Wednesbury unreasonableness. So it was considered that something is to be viewed as Wednesbury unreasonable if no reasonable person in that situation could ever make that decision. Now, that's a little bit of a higher statement than you might think, or a higher standard than you might think, because you might just be thinking, well, obviously, something is unreasonable if a reasonable person wouldn't do it. But it's a bit more than that. It's not that a reasonable person wouldn't do it. It is more specifically that a reasonable person could never do that. It would be impossible for a reasonable person to make a decision if it is Wednesbury unreasonable. That is the point of that. So that is the idea that you would ascribe to the concept of Wednesbury unreasonableness. However, when it comes to administrative decisions which are made in the context of human rights, the Human Rights Act specifically, there will be the requirement of a higher standard other than that of simply Wednesbury unreasonableness. And we can see this in the case law, and we can see this in some of the basic principles. One such example is obviously the case of Crown versus the Ministry of Defence from 1996. So this case illustrates an interesting point in relation to Wednesbury unreasonableness as it pertains to human rights. Now, there are basically two elements that we have to think about here. We have to think about the way in which this case, the Smith case, actually was ascribed in English law, the domestic system, and then how this principle then gets dealt with in the European Court on Human Rights in a case which applies the ECHR. The case concerned a number of military personnel who were known to be homosexuals and or engaging in what was known at the time or considered at the time as, quote, homosexual activities. Now, this is seemingly just an uncontroversial way of saying basically sexual activities of a homosexual nature. So, a total of 4 military personnel would be dismissed on the ground that they were known to be homosexuals or engaging in homosexual activities, at which point they challenged this decision. And they challenged this decision in a judicial review case. And they challenged it reasonably on the grounds of the decision violating their rights to private and family life, which is their Article 8 rights under the European Convention on Human Rights. They also made the argument, in addition to this, that the government violated the EU Equal Treatment Directive in relation to the dismissal as well. So they made sort of two tracks, one in relation to EU law, one in relation to the law on the European Convention on Human Rights. Now, the Court of Appeal held that it was in fact reasonable to dismiss them on the grounds that they were homosexuals. They noted that a higher standard ought to be applied in circumstances where a challenge is made on the grounds of reasonableness when it concerns human rights infringers. So when it comes to human rights infringers, it should be a higher standard than that of simply Wednesbury unreasonableness. Since this involves an infringement or an alleged infringement of the human rights, a substantial justification would have to be required to show that it was not irrational. The courts held that, essentially, to suggest a policy is irrational when it is supported by both houses of Parliament and was considered at the time to be within the reasonable limits of this support, it would not therefore be proper to use judicial action in this circumstance, especially as it also pertains to human rights. So that is why they concluded, therefore, that the decision was considered to be at least reasonable as under the judicial review law that we had. So simply put, when it comes to these kinds of circumstances, irrationality is a particularly high threshold to meet. But we then also get an application of this case to the European Convention on Human Rights, the European Court on Human Rights. The case of Smith and Grady versus the United Kingdom in 1999 is the exact same set of factual circumstances, but it is, of course, just an appeal from the previous case of the Court of Appeal all the way up to the ECTHR. Now, rather than suggesting that there was no incompatibility between in relation to their human rights, the ECTHR in fact concluded the opposite. They said that at this level, essentially, the policy was in fact incompatible with their Article 8 rights. And so, as a result of which, they also held that when it comes to human rights protections, the traditional approach of Wednesbury unreasonableness is not adequate, and that instead they ought to argue for a higher standard to be placed. And at paragraph 143, they say the following. They say, quote, "The threshold at which the High Court and Court of Appeal could find the Ministry of Defence policy irrational was placed so high that it effectively excluded any consideration by the domestic courts of the question of whether the interference with the applicant's rights answered a pressing social need or was proportionate to the national security." So essentially, with regard to the standard being considered so high, it essentially meant that the domestic courts were useless to consider any such violations of their Article 8 rights in relation to this policy being challenged on the basis of judicial review, because it rendered them essentially meaningless. It excluded any consideration by the domestic courts, which is essentially what the ECHR claims in this particular case.